Honourable plea on the matter of Begum and the Secretary of State for the Home Republic, Part Act.
My Lord, just by way of introduction, a few submissions. The first is an obvious one. This is an appeal to the Court of Appeal. I'll come in due course to the summary of the correct approach that was set out by this court in a related appeal, or at least an appeal out of the same context in U3, Bundle 3, tab 58 in due course. But the proper approach of this court to criticisms of SIAC in their treatment of the evidence is set out or summarised in paragraph 10 of that decision. Of particular importance here to start with this introductory point, because you have before you a long, balanced and very careful judgment from SIAC, itself exercising appellate functions, which again we'll have to come back to and have a look at, but itself also, perhaps more pertinently, having had and having taken the opportunity of considering a mass of evidence, and indeed on some of the key aspects of the appeal, live evidence, including from the Security Service witness E. And moreover, in your function as the appellate court, you are considering a decision of SIAC which involved inevitably both nuances and balances, but which was at its heart about national security. And I turn very briefly to that topic because national security and the question whether Shamima Begum represented a threat or a danger to national security at the time the Section 40 decision was taken was, for obvious reasons, the central and key focus of that deprivation decision under Section 40. The power to deprive, that you will need no submissions from me to tell you, is an obviously important power conferred on the Secretary of State by Parliament, and in recent years it has been a key part of the ability of the government to protect the public from the risks of terrorism. It does that by preventing the person deprived, as long as they have dual nationality, it prevents the person deprived from exercising rights of entry into and abode in the United Kingdom, and it imposes instead the controlling need for them to seek, before entry, leave to enter. And that combination represents a significant control and a significant protection, and as such, this Section 40 power is, we submit, a key power in the Secretary of State's armoury, exercised in pursuit of a powerful and compelling, perhaps the most powerful and compelling public interest, namely to protect national security, which, as you are all well aware, is really shorthand for the protection of the public. And it enables the Secretary of State in appropriate cases to deal with real and tangible and current threats to national security / the public. The decision in this case was, as you know, taken on precisely those grounds, on the basis that to deprive Shamima Begum of British citizenship would indeed be conducive to the public good, because it was considered by the Home Secretary, acting on the expert and experienced assessment of the Security Service for this purpose, it was considered that she presented a risk to national security. There is now little or no challenge at all, either to the ingredients of that national security assessment, including, and it is perhaps important to note, including the updates that were provided on the national security assessment. You're aware that the matter was further considered in effect during the course of proceedings, and indeed in the light of the evidence produced by Ms. Begum. You would have seen references to various expert reports in some of the later national security assessments.
You say now little or no challenge. Was there at one time challenge?
There was an attempt to challenge
Yes.
national security
Yes.
bases on various parts and to picket it. part was why witness E was cross-examined in open. That's one of the things. But there isn't any longer, it appears. Indeed, it might be thought that Mr. Squires sought to try to turn the approach to national security in trial, and the difficulty of trying to undermine on any fruitful basis the assessments that were made about threat to national security. He did so almost regardless, it might be thought, of the potential damage to Miss Knight's arguments. He sought to turn that into an opportunity when he came to the simplex arguments, his flip side point, which I will come back to in the context of simplex. But as it were, there isn't any challenge any longer to any of that national security side of this case, which is the central feature of the case. Indeed, on the contrary, as I've just indicated, what they now seek to do is to say, well, take that as read and take how difficult it all is to challenge that and turn that on its head. I respectfully submit, or I will submit in the context of simplex, that isn't an appropriate approach, and the flip side point doesn't work at all, but that's not relevant for present purposes. But it does remain important, at least, in opening my submissions on this appeal, to start at least with the key feature of this case, which is national security. And I start very, very briefly with the correct approach in principle to national security assessment and how those are to be done, to be approached. The focus, as you know, of section 40 is squarely and directly and centrally on the question whether the individual represents a danger to national security. That assessment, as we all agree, is essentially a matter for the Secretary of State acting on expert advice on national security from the Security Service. I wanted to deal very briefly on that front only with three cases. The first of them is the Begum decision in the Supreme Court. That's in Authorities Bundle 2, I think, tab 49. This, again, as you'll be very well aware, was Miss Begum first time round, as it were, going to the Supreme Court on the question, should she be admitted into the jurisdiction as a necessary concomitant of the fair pursuit of her SIAC proceedings. That was essentially the issue. But that context doesn't matter for present purposes. What I'm going to this Supreme Court authority for is for the analysis of Lord Reed on how you approach questions of national security. And you will see, and probably some of you, many of you, all of you will recall that what he did was to place considerable reliance on the analysis of Lord Hoffman in the Raymond case. You have Raymond in the Raw if you want it in the Raw. I'm not going to go to it in the Raw, but if you want it in the Raw, just to note it's in bundle 1, tab 14. But can I pick up Lord Reed's judgment behind tab 49 of paragraph 51, page 1526, I hope, in the number of the bundles. And what I might do, given that I want to just refer you back to a few of these paragraphs, is to invite the court, if it would be convenient, to read the paragraphs I'm identifying for yourself.
Yes.
Rather than my reading out. Paragraph 51, please, first.
Mm-hmm. Yes.
Then there is a summary of what the law looked like at the time, as you see in paragraph 52. And that principally, that issue or that set of points goes principally to the issue that arises in our cross appeal or respondent's notice about the nature of the appeal. Because you'll see that section 4 used to be in a particular form and now it's been repealed and all of that. So I'm not going to take up long with that, but just note that about paragraph 52. Then go, if you would, to paragraph 55, where he gets stuck into the correct approach on national security. And the points that he takes from Lord Hoffman's speech in Raymond. 55, if you would read, please, through to the end of 57. And you'll see the various themes for why it is in Hoffman's speech why it is that the approach of the courts is as hands-off as it is. So 55 through to the end of 57, if you would.
Yes.
59, he deals with a possible contrast in approach between Lord Slynn and Lord Hoffman, but effectively says, notably because section 4 had been repealed, he effectively says, see top of page 1529 within paragraph 59, second line, it is Lord Hoffman's approach which is now more relevant. So he's on Lord Hoffman.
Sorry, what was that?
That's top of page 1529 within paragraph 59. It's a
Yes,
short
thank
point,
you.
but he's there dealing with, is there a difference of approach between Lord Slynn and Lord Hoffman? Don't care is the answer, because Lord Hoffman now is more relevant because section 4 has been repealed, which was the part of the foundation of Lord Slynn's analysis. So he deals with those features, particularly 55 to 57 of Lord Hoffman, which are indicating the correct approach. And then at 60, he turns to the question, do you get to the same place because it's an appellate process? And so 60 through to the end of 63, if you would, as the next bit. So 60 is all about the appellate process. Effectively, it's on the same theme. It's entrusted to the Secretary of State, the Commission is an appellate body, and so on. In 60, the next factor at 61, it's an evaluation of risk. So considerable margin. And then finally, democratic accountability, para 62, drawing on the previous analyses of the House of Lords and then the Supreme Court in the A case and in Lord Carlisle, which is the case about admitting the Iranian dissident to speak to parliamentarians in the United Kingdom. Lots of respect, because it involves matters for which the Secretary of State is democratically accountable.
Yep.
Then he turns to the nature of the appellate provisions and the statutory context or structure within which the issue arises. Obviously the same there as here, same person, same issues. 63 starts that consideration. So you might note 63.
It's really through to 71, isn't it? It's the
It
whole
is,
section. through to
exactly so.
71.
And then the key bits really are 65. To save me going back to this, can I meld in, as it were, the points I'm going to make about rights of appeal and whether it's like a JR or whether it isn't like a JR and all of that. But 65 in particular on that. And then 66, he's back to the idea that section 40 sub 2 confers the discretion, or is the discretion conferred by Parliament, halfway through 66, conferred it to the Secretary of State, therefore be exercised by the Secretary of State and no one else. No indication in the 81 and 97 Act which govern rights of appeal. Parliament intended the discretion to be exercised by or at the direction of SIAC. They can, however, review the exercise, and so on. And then, as my lady says, through really to the end of 71. And note in particular, again, to save me going back to it when we get to the true nature of the appeal under the Act as it now stands, and what its true nature is, note in particular 69, if you would. And you'll see the analysis which is set out there, particularly in the second sentence and following. That's not to say that SIAC jurisdiction is supervisory rather than appellate. Its jurisdiction is appellate, and references to a supervisory jurisdiction capable of being a source of confusion. Nevertheless, the characterisation of the jurisdiction as appellate doesn't determine the principles of law which the appellate body is to apply. Hence, you can be appellate, but nevertheless, as a matter of correct approach, in principle, accord respect to the decision maker where they have, for various reasons, respect to be accorded to them, the reasons having been identified and analysed earlier. And then he pulls together the themes, as my lady drew attention to in the attempt no doubt to hurry it up, 70 to 71. That's the punchline. But it's quite important to see why you get there, because the punchline in 1771 is in summary form, and it follows quite a lot of detailed analysis and setting out of the strands, which are then drawn together in those two paragraphs. So that's Begum. I wanted then to go, because there was all sorts of uphill and down dale analysis about what that meant in various decisions of SIAC, and the points have been revisited in U3, which is an authorities bundle 3, so you can put bundle 2 away if you're physically working. Bundle 3, tab 58, if you would, for U3. I think Our Lady of the Lady Chief Justice was involved in U3, being before the court by Lady Justice Leng. The Lord Justice being very familiar with these issues, you were also, I think, involved in an appeal from one of these number of cases. But U3 is number 1 and tab 58, page 1814. And again, can I do the same sort of approach? Paragraph, and I'm going to merge in what is the beast you're dealing with, what kind of appeal are we dealing with here, is it like a JR, what the limit, how do you approach it, and also approach to national security. The summary of conclusions, I'm going to put it as a summary of conclusions of the court, because Our Lady and Lord Justice Peter Jackson agreed that without more, so the court's conclusions are paragraph 5 in summary form. Then she specifically approaches the distinction between appeal and a JR in the section, as you see from the title above, paragraph 6 on page 1817. And note the structure of the Act and the distinction which is drawn on the face of the Act, that she draws attention to at paragraph 6. I referred you earlier to paragraph 10 in relation to the approach of the Court of Appeal on an appeal from SIAC, and she draws attention to the fact that it was an appeal on a point of law, and what approach you should take to the usual test that you apply, which is whether or not it was wrong, and in particular pulls out the 4 Roman numeral points that she does from Volpi and Volpi in the tailpiece of paragraph 10. And then really the bits that we're particularly interested in perhaps just before we get to those, can I pick it up in P3 on her analysis and drawing attention to P3 on page 1833 at paragraph 73. This was, I think, the case I had in mind where Lord Justice Dean was a member of the court.
Yes.
73 through to 75, I'm sitting with Stephen Irwin and 73, 75, you wouldn't mind. I think it was Lady Justice Leng was the other member of the court in B3.
Yes.
You can see the sort of themes that we saw in the Begum case, and it goes both to the correct approach to analysing national security and what approach should be taken, and also to what the nature of the beast that you're dealing with here is. So those paragraphs are of some interest. And then what might be thought to be the key bits are perhaps between, most of them I think have been sidelined, but are perhaps between 168 on page 1853.
Just before you pass on from
Yes, my lord, sorry, I'm going too quick.
74 and 75, you refer back to what Sir Stephen Irwin said in P3. Is that accepted to be correct?
My lord, yes, from our perspective it is. And it feeds in, I think, those themes feed into the analysis of the court in U3, as we see when we get to the later parts of the judgment, starting at 168.
Yeah.
Again, I'm not laboriously going to go through all of those paragraphs, but I would invite the court to read and pay attention to 168 to 178. It's that kind of block of analysis, including in particular 171 to 172. So 171 to 172, and sorry, can I also ask you if we're just going to pick out some paragraphs to read from that section? My learned friend at night took you yesterday to 174, on which we place reliance. This is the limitation on the findings of fact jurisdiction. It's as long as it respects the limits in Raymond and Begum. 4 lines up from the bottom of page 1855, so 174.
Well, that's the key point that was at issue.
It's a key point there. And the same theme is 175, I think also 175. Taking that analysis forward. So you can make findings of fact, that's the 175 first half, but be careful, and be particularly careful because in cases that are coming before SIAC and the Court of Appeal in this context, the caveat is, and the note of caution is in the second half of 175, starting with the line facts will not be in dispute, and then picking it up there, you see the contentious aspects of the assessment in a case like this will often turn on questions of motivation, which will depend on inferences or on similar issues. SIAC is not a jury deciding whether they intended to commit a crime. Drop down a few lines. The finding is part of a factual picture. It must apply the tests in Raymond and Begum. Since a finding about motivation necessarily involves an assessment based on inferences from primary facts, SIAC must bear in mind that finding about motivation cannot displace the contrary assessment. Secretary of State, as long as there is material which rationally supports such a contrary assessment. And she returns to the theme that we saw earlier about the differences between judicial review and appeal, and the fact that it's an appeal is only a starting point because you get into what the proper functions in principle then of the appellate body are or should be. That's the theme in 176. Back into all those themes we saw from Raymond in 176. So that is U3. I'm sorry to muddle up the points, but you see why it's necessary to consider what the nature of the appeal is in order to consider what the correct approach is to national security. So the issues tend to blur one into the other. So right, perhaps to take them as a piece. The only other case I wanted to deal with is Hashim Ali, on which considerable reliance appears now to be placed by Ms. Begum, and that's the Lord Care paragraph. And it's right to point out that it was a Lord Care paragraph in a dissenting judgment which received no other support from any other member of the court in Hashim Ali, and has not been picked up and approved, as it were, and dragged into the main body of actual binding case law from the Supreme Court in any subsequent case. But in the end, despite an attempt to rely upon it, there was and has been no criticism of the way in which SIAC dealt with Hashim Ali. If you have the judgment of SIAC to hand, I'm going to take Hashim Ali by reference to the paragraphs which dealt with it. I'm going to make a short submission, but in the absence of any challenge, we take that to be, and we take it to be anyway, the correct analysis of how you should approach that paragraph in Hashim Ali. See paragraphs 31 to 32 of the SIAC judgment, i.e. the SIAC judgment from which I think it's in the core bundle.
Yeah,
of tab
page
7,
102.
Page 102. And I take in particular from paragraph 32, perhaps the obvious point, which is correctly made by SIAC, which is that if you're dealing with section 40 with its central focus on national security, whilst there may be other factors that potentially feed in, the Secretary of State would be properly entitled, exercising the power, particularly given the statutory context and the wording of section 40, is entitled to give great weight to the fact or to the assessment that an individual poses a threat to national security. That's halfway through paragraph 32. We respectfully submit that the balancing or the weighting is not even.
I mean, the way Miss Knight put it was to say, well, as it were, take that, but if it is all about national security, then you've got to consider matters that are relevant to national security, and the trafficking risk is relevant to that assessment, and that's something you're going to address
I'm going
at
to
some
address
stage.
it in some detail because that's a central
So
theme.
even if you're right that it's all about national security,
It still feeds in.
and I think one of us asked a question as to, well, why is it relevant, and Miss Knight gave an answer.
Yeah.
So you'll deal with that.
I'm going to deal with that in some detail.
Yes, thank you.
That's what I was going to say. But just on the correct approach to the authorities, Hashim Ali, we respectfully rest on SIAC's correct analysis and unchallenged analysis in 31 to 32. So it is clear, therefore, that it's extremely difficult for an appellant successfully to challenge that expert and experienced assessment by the relevant intelligence agencies that a person does or is assessed to present a risk or a danger to national security. That must be a fortiori in this court, where SIAC has produced a careful and balanced and detailed judgment that it has, and where it heard live evidence on these matters. And our submission on principle is that U3 in effect reinforces that approach, taking forward the themes from Begum, solving the conundrum which SIAC referred to in this judgment, solving the conundrum about how it is that it could be in effect something like an appellate review, but nevertheless you were allowed to take into account after acquired evidence or material. U3 addressed that issue as well, and in particular addressed that issue. And we do submit, therefore, that national security is at the heart of this case and provides the framework within which the central allegation of trafficking sits, and also provides the framework within which, if we get to it, the simplex point sits. What then are the key elements of the national security case? Again, given that it's now uncontroversial, subject to the points that are raised on appeal, I can take this briefly. The key elements of the national security case were considered with care and in some detail, particularly in SIAC's judgment, paragraphs 118 to 138. And I highlight only 6 short points by way of introduction and summary of that analysis. Shall we see in open, and more to be said about that in closed. The first point is that Ms. Begum travelled to Syria with 2 others. She planned that travel, is the assessment, and had made a conscious effort to conceal it from the authorities, using her older sister's passport to do so. That's the National Security Assessment, which I'm going to call ONS1, if I may. I will note ONS1, paragraph 8, supplementary bundle, page 756. The assessment was that the travel was voluntary. I'll obviously come back to that in the context of the point I was just putting to in the context of the trafficking case. But the assessment was that the travel was voluntary and demonstrated her determination and commitment to aligning with ISIS. ONS1, paragraphs 10 to 11 and also 26. See supplemental bundle 756 to 758. Secondly, motivation. The assessment was that she travelled for the purpose of aligning with ISIL, and once in Syria she did in fact align with ISIL. Alignment for this purpose denotes, and this was the description of alignment that was used in ONS2, that's the second of the national security assessments. ONS2 at paragraph 10, supplemental bundle, page 816. It denotes, quote, the adoption of and or mental positioning alongside ISIL ideology, which may be coupled with physical joining or co-location with ISIL. The assessment was that she did that with her eyes open, and that assessment was based in particular on the fact that the ideology of ISIL and their uncompromising brutality, take the phrase from the assessments, has been widely covered in the media. That was accepted by SIAC at paragraph 118 of the judgment. If you want the detail of it, see for that purpose Larkin 2, that's his second statement, paragraphs 22 to 31, supplementary bundle, page 855. And the assessment in the broader ISIL statement of April 2017 at paragraphs 21 to 22, supplementary bundle 829 to 830. And she knew about those things and those matters. See, for that purpose, the interview at supplementary bundle, page 774 to 775. All of that, in relation to motivation and doing so with eyes open and so on, was reconsidered in the light of the reports that have then been produced during the course of these proceedings by or on Miss Begum's behalf. It was reconsidered in ONS2. See especially paragraphs 5 to 7 of ONS2, supplementary bundle, page 815, and that assessment was maintained. And SIAC recorded and specifically accepted the evidence of witness E that Miss Begum would have known what ISIL were doing as a terrorist organisation at the time. See judgment of SIAC, paragraph 163. Thirdly, the threat posed by those who travelled and aligned has, for obvious reasons, been the subject of the most careful consideration and assessment by those best placed to make it, the Security Service. See, for that purpose, the ISIL statement. And the key assessments, perhaps in that ISIL assessment for present purposes. I'm not going to go through it because none of this is controversial anymore. But the key assessments in that ISIL statement are at paragraphs 2, 9 and 55, it might be thought, supplemental bundle, round about page 824. And those assessments, the original assessments, I think in the 2017 ISIL statement, were then reviewed and maintained, as one sees from supplemental bundle page 843. And there was also produced an ISIL statement addendum in June 2019, supplemental bundle 845, considering specifically the threat posed by women who've gone out and aligned. And those statements demonstrate not merely the fact of threat, but also how the creation of that threat comes about precisely through the process of radicalisation and, importantly, desensitisation, which is a concept frequently referred to in those ISIL statements. And those outcomes occur however they got there, if I can put it that way. It might be thought that the young are particularly problematic to those sorts of influences. And it leads on perhaps to the fourth point, which is that the fact that someone is or has been radicalised is not inconsistent, and indeed probably positively supportive of the fact that they may nevertheless pose a real national security risk. And it's quite clear that that applies just as much to women and or children as it does to adults. That was essentially the conclusion here. She may well have been radicalised, but ... Fifthly, to return to the basic facts of Ms. Begum, she left the country in the manner I've described. She travelled to Syria. She married an ISIL fighter, Mr. Reddick. She lived in Raqqa, the capital of the Caliphate, with him. And she remained there until 2019, 4 years later, into the last pocket of ISIL territory, Baghouz, Baghuz, where she was ultimately captured by the Syrian Defence Force, the SDF. Sixthly, the Security Service assessment of the risk posed by Ms. Begum in the recommendation to the Secretary of State and in the two national security assessments has been clearly set out. We see it in particular from ONS 1 at paragraph 12 and following, supplementary bundle 756, for her departure and her capture in February 2019. See paragraph 18 of that first national security statement at 757. And that national security assessment also took into account the interviews that she gave after capture, in particular in paragraph 20 and following, including the Times interview, in particular paragraph 20 for the Times interview, page 772 of the supplemental bundle, the Sky interview, paragraph 24, page 774, and the other interviews summarised at paragraph 36. And I'm not going to go back through those, but you remember the bits. The first time she saw her head in a bin, it didn't faze her. The comments she made about the Manchester Arena bombings, and all of that. And in the view of the security service, none of the assessments were undermined or altered in their essentials by any of the materials produced on her behalf offering the variety of potential theories and hypotheses without any direct input from her in terms of evidence about her behaviour. And we know that because they were carefully considered for that very purpose. See ONS 2 at page 815 and following. The short point is that the assessment that she was a threat to national security was one which was maintained in the face of those challenges and of those points being made on her behalf. And it was maintained by those who have the particular expertise, experience and responsibility to make those judgments. That's all I wanted to say about national security. I wanted to turn, if I may, to trafficking. I do, I've done that summary by way of lead into the trafficking allegations. And I've done that because the allegation of trafficking has to fit within the framework of this statutory scheme and in the framework of this appeal. I wanted to start with 6 relatively short points, or very short points I hope, about trafficking before coming to the grounds of appeal specifically and the core way in which she's now, Ms. Knight has now helpfully put the argument to this court. So 6 key points first before coming to the matter specifically. First, the power to deprive is conferred by Parliament in relevant respect here to protect the public from terrorist threat. It exists to protect that greater good, despite the obvious detriment to the individual deprived. And the powers are to be exercised so as faithfully to adhere to and to serve that parliamentary intention. It's an aspect of Padfield, if you will. That's the first point. The second point is that the basis for that power and its exercise in the present context involves an assessment by the expert and experienced people who have to do it of whether on the particular facts in relation to a particular individual someone does or does not represent such a danger and whether or not that danger should lead to deprivation. Third point, how to assess the national security risk and what inquiries to undertake and what is material to that assessment is to be approached not merely on the basis of the authorities that we've looked at dealing with the correct approach to national security of SIAC and indeed then of the higher appellate bodies, but also on the basis that those matters are essentially for the rational judgment, at least at common law, for the rational judgment of the Secretary of State. You don't need to be reminded, I think, of the basic case law about material considerations, and that being a matter of rational judgment subject to the taxonomy that says sometimes it's a statute that compels or renders some particular factor mandatory. It's Lord Cook in Creed NZ, taken forward, I think, in the DSD decision, the war decision of the Divisional Courts of Brian Leveson, as Justice J and Garn. But they effectively establish and reinforce that taxonomy and identify that when you're dealing with matters that are not dictated by statute, as it were, it's a matter for the rational judgment of the decision maker. That's DSD. I'm not going to invite you to turn it up, but if you want the reference, it's DSD, especially paragraph 141, authorities tab 42, bundle 2, tab 42, page 1271. That section around paragraph 141 deals with that analysis. And it's also a theme that was picked up and dealt with by the Supreme Court in the Friends of the Earth case to the same effect. Authorities 2, tab 48, paragraph 121 especially. So authorities 2, tab 48, paragraph 121. So that's material considerations and the case law and the principles that govern material considerations and when they're mandatory. And in relation to inquiry and how far you have to chase down particular points, that's really Thames side. And it's the same punchline, which is that how far to inquire, how far to chase down particular points is again a matter for the rational judgment of the decision maker. C, perhaps most authoritatively for that point, the Court of Appeal in Balaji Gari, the judgment delivered by Lord Justice Singh, authorities, bundle 2, tab 41, paragraph 70 has all you need to know about that Thames side. So they're all matters for the rational judgment of the Secretary of State. That's the third point, that correct approach. Fourth point, if an individual does pose such a danger, i.e. danger to national security, how they come to do so, in other words, how they got into that state of posing that threat, is, we respectfully submit, not important. It is the fact of the threat that is important, not its derivation or its genesis. What matters, given the protective purpose that the power in the Act serves in section 40, is that they do pose such a danger. So it is no answer to the powers exercised to say that the public must be exposed to danger because events or circumstances, however unfortunate, have conspired to make it.
Now, is that a question of degree, or do you say it's irrelevant outright how they got into the state of the threat?
Well,
Question of
I'm going
weight
to make the
or-
submission in due course that the legal analyses of trafficking are irrelevant, but it may be relevant to consider things like motivation or how they travelled and whether they were suborned and so on.
Right, thank you.
That's going to be the distinction I'm ultimately going to be drawing.
Thank you.
But I make the point, as an overarching point at this stage, that it isn't an answer to say, well, I got into this state of threat because, or how. And the reason that that is so is because no one disputes that it's entirely possible for a person to have been trafficked or manipulated or brainwashed, or to have had their travel facilitated by nasty people or similar, and yet to be the most serious danger to the public. And one can see that because not merely in point of principle could you nevertheless still be a danger if all of those things have happened, but it may also be that if those unfortunate things happened at a particular point in time, further things have happened subsequently. And in Miss Begum's case, the 4-year period when she was in Syria being subjected to all of the influences that were in play there. And that, we submit, is critical to an understanding of the power in question and the constraints upon its exercise. The fifth point is this, and I touch on it briefly because I'm going to come back to it in the context of Article 4. It may go more directly to the point my lady was putting to me a minute ago, but the trafficking and deprivation regimes have fundamentally different bases and roles. And the correct approach is to recognise that we are here dealing with a power to protect the public, which Parliament has conferred. That is the lens through which the issue is to be approached. So where someone is within the jurisdiction, i.e. within the United Kingdom, and so able to be assisted in all of the ways envisaged under the developed trafficking regimes and the NRM and all of that are in place here, it's understandable that the trigger for the engagement of all of those protections should be the exercise of those powers on, in effect, a precautionary basis. The focus in the trafficking regime is on the protection of the individual, and there's really no countervailing public interest at that point. But here the regime is different. The regime in operation is the deprivation regime, and the rationale is entirely different. It is the protection of the public at large. That is why the test is conducive to the public good. Sixthly, by way of general introductory point, the power to deprive is of course subject to the usual public law controls, material considerations, rationality and so on. It is that which determines the legality of the exercise of the power and fixes the relevance of the circumstances of, for example, Miss Begum's departure for Syria. All of the circumstances, including those which might also be relevant to a trafficking analysis, might be relevant to the assessment of the threat posed, because they bear, and it's important that the because is in there, it's because they bear on aspects of the expert and experienced assessment of the relevant statutory question, which is, does the person pose the threat? But that's the limit of their relevance.
Can you just go over that last point again?
Yeah. The point I was making was that all of the circumstances, including matters which might be relevant to a trafficking analysis, in other words, whether you
Whether you were exploited, whether you were
exploited, all of that, might be relevant to an acknowledgement that some of those base facts might be relevant to the threat assessment. That's really the short point is being made. So I'm not denying the potential for the underlying base facts to be relevant. And you won't be surprised to hear me say that when we get to it, my submission is going to be, and they were considered for that purpose, as one sees from the National Security Statement. But they're relevant because they bear on the relevant statutory question, which is the person a risk?
and not, you'll come on to this, and not because they come in by...
And not because they come in and they're given a particular label which happens to be trafficking. That's the critical feature. And on a slightly different aspect, how far to chase down the trafficking possibility, assuming one has a credible suspicion, as SIAC found, how far to chase that down, whether that's likely to be profitable, and whether it's likely to feed in, and if so, how to the assessment, is a matter for the rational judgment of the Secretary of State. That's an aspect, as it were, of Thames side, if I was analysing that in public law terms. And you may well conclude, as a matter of that analysis, that the person may well have been trafficked, or it's possible, or you can't rule it out. But nevertheless, you've addressed the question of how they left, with all the echoes of trafficking that contains, and then you go on and look at the broader picture, including in particular what happens thereafter, how long they've been away, what they've been doing, what the intelligence tells you about this, that and the other. It's all part of that security assessment. But the label or conclusion of trafficking does not, we submit, and plainly was not intended by Parliament, to cut across or cut out or preclude the powers. I say I'm going to come back to that specific point in dealing with the grounds.
Are you going to say at that point that the possibility of her having been a victim of trafficking was actually taken into account?
I am going to say that, and I'm going to say it was taken into account of the base facts that bear on that were specifically considered. And the trafficking allegation is centrally premised on the voluntariness and or what happened to her before she left the United Kingdom. That's the core of it. And those matters were the subject of assessment and detailed consideration.
I was thinking of trafficking for the purposes of sexual exploitation rather than in a more general sense of manipulation to go and join the ISIS semi-state.
Yes. Well, that goes to the motivation of the trafficker. It's a well-acknowledged feature of trafficking principles that is one of the potential bases on which people are exploited, manipulated and moved and so on. So
I don't recall it being referred to in the materials we've seen. But
I don't think the sexual exploitation part of it is. It may be in a broader sense. I think there are some references in the broader ISIL statement about people being taken out or moved out to Syria for the purpose of being married off to jihadi fighters.
Jihadi brides, definitely. The concept of the jihadi bride.
The jihadi bride is well recognised, and we'll find you a reference. I'm pretty sure it was in the ISIL statement, so it's in that general analysis. But it might be thought that that, as it were, end game or motivation of the trafficker is of rather less importance than the why they did it. Is rather less important than how it happened and whether the influence suborned the will and all of that, which is the essence of the case that's being made against me. But as I say, we'll find you a reference in the ISIL statement to jihadi brides, if that would help. I wondered if I may, to try and deal with just before coming to the Article 4 way of putting it and the common law way of putting it, I wanted to try and take the core of the oral argument that was being advanced by Ms. Knight under both Article 4 and under public law, head on before picking up specific points relating to those two slightly discrete regimes, because under both it is suggested that that's Ms. Knight was making really a very modest submission, ultimately that through either or both of those routes, trafficking and its prevention needed as a matter of obligation to be considered. So that was the modesty of the submission. I'm just saying you just have to consider it. I'm not saying you have to do anything, you don't have to investigate or do any of that, you just have to consider it. I note with great respect to her that was not the limit or the modesty of the case that was advanced below, so I do not accept the criticisms of SIAC that they misunderstood the case that was being advanced by her. It may be that in the usual way SIAC and particularly the chairman, no doubt, was trying at various points to cast the submission that might be made on Miss Begum's behalf in a light which was at least tolerably favourable, because it introduced the necessary logic to make the submission coherent, a point I'll develop in a moment. But I perhaps don't need to get sucked into the history. That is now the limit of the case that is now being advanced on this appeal. In other words, she's purely saying it's consideration. You don't have to do anything else, just pure consideration. So we note that to start off with. I don't accept the criticism that the made of SIAC, they misunderstood it. That was the case that was being advanced, particularly in relation to the investigations that needed to be undertaken and in relation to repatriation and all of that. Those were arguments that were squarely being said and mounted. It's also perhaps to be noted that it isn't modest in its effect. It won't have escaped the court, I know, that the position, as we understand it now, is that Miss Begum, having gone past the age of 21, is no longer a dual citizen. So, if I can put it this way in shorthand, for her, from her perspective, or from the perspective of those who act on her behalf, any error will do, as long as it leads to the old decision being quashed, because they'll know that if that is the position, then statelessness will rear its head in relation to any future decision, and that might well be, perhaps would be a game changer. Our overarching submission in relation to the way in which the case is now refined, if I can put it that way, so as to avoid too much controversy about the bar.
So we're looking at grounds 1 and 2.
I'm looking at grounds 1 and 2. I'm looking
Yep.
at Article 4 and PL,
Yep.
public law, and I'm taking them together
Yes,
to try and respond directly to the oral argument, which
Yes.
effectively
thank you.
applied to both through different routes. I'm going to come specifically to both Article 4 and public law in due course, but just to pick up 3 points. Our overarching point, before I get to the 3, our overarching point is that SIAC committed no error of principle in concluding that there was no obligation under either legal route, Article 4 or public law, to consider the particular features of trafficking relied on in principle or on the facts. And the first point I wanted to make by way of response to the consideration way of putting the case that's now at the forefront of Miss Knight's submissions is that the trafficking definition is very broad. In other words, whether you fall within trafficking, you look at the definition of trafficking, the definition of trafficking is very broad. And not merely that, but the regime of trafficking does include various principles, for example, about minors and what you can ascribe to their mental state and all of that, but cannot be relevant as the lens or the prism through which the Section 40 power or decision making has to take place. Trafficking is not, we submit, the relevant lens, and for reasons I'll develop in a second, indeed may not just be not the relevant lens, but may be a lens which is antithetical to the proper exercise of the Section 40 power. Section 40, I emphasise, is a power to deprive on national security grounds, in summary to protect the public. That is, we submit, the proper focus. And we do submit, I can't remember which member of the court, I think it might have been Lord Justice Bean who alighted on it, we do submit that 257 in SIAC's judgment is very, very important and might indeed be thought to be key. reject the trafficking lens in that paragraph, and we respectfully submit that the points that are made in doing so in that paragraph, and there wasn't much of a disagreement, if any disagreement, with the detailed analysis in that paragraph when the question was put to Ms. Knight directly, but we do submit that those points are well made and are very, very important. So, for example, the basic stand-back point is that the broad definition of trafficking, the absolute or harder rules on minors, the other features of trafficking law that apply, are simply inapt to provide a lens through which to consider what is essentially a national security directive power in section 40. So, to take the wide definition of trafficking, the case is essentially, Ms. Begum, that anyone, certainly anyone who was a minor at the time they travelled, even if they later became adult, anyone manipulated or subjected to ISIS propaganda or recruitment whose travel is facilitated, is, as almost everyone who travelled will be able to say, is or arguably may be, credible suspicion, to take the Article 4 test, a victim of trafficking. And so not merely is that, as it were, inapt as a lens through which to exercise the national security power, but worse, it might skew the assessment of risk. It risks skewing that assessment in a thoroughly unsatisfactory way, precisely because the fact of trafficking, e.g. at the point of leaving the United Kingdom, is not inconsistent in any way with posing a possibly very serious national security risk. And indeed, the fact of manipulation or radicalisation are itself factors that tend towards the existence of such a risk rather than against it. And there is a slightly separate aspect of the same point, which is a point made by my Lady Justice Whipple, I think, which is that the fact that trafficking exists can play both ways. we respectfully thoroughly agree. The fact that a person was trafficked will almost certainly in this sort of context be because they may have been radicalised or suborned, and that may be a very considerable importance in positively supporting the existence of very real national security concerns. And the consequences, we submit, of dragging in that species of law, that body of law, and making it relevant to the matter considered, needs to be viewed with very clear eyes, given the paradigm responsibility that Parliament has conferred on the Secretary of State under Section 40. Miss Knight did submit below that at least in the case of someone who travelled as a minor, the Secretary of State could not deprive unless satisfied of a negative, in effect. And the negatives were that they hadn't been trafficked, in fact, after full investigation. And B, that's A, and B, that if they had been trafficked, there was no nexus between the trafficking and the thing that led to deprivation. That's impossible. It would mean that a person could, extremely unfortunately, no doubt, have been exposed to propaganda and manipulated and facilitated, and then spent years under the pernicious radicalising and desensitising influences that we saw referred to in the national security assessments. And indeed, there might have been active participants in some of the activities, subsequent training or worse. So we submit that SIAC was right to have characterised the case that had actually been advanced before then below in the way that they did, and then to reject it. In particular, and I'll come back to this paragraph because it's one of the paragraphs that is directly criticised, in paragraph 244, when dealing with Article 4. That's the first point I wanted to make about the inaptness, or possibly worse, of using trafficking as the lens in relation to the exercise of the Section 40 power. And you'll see it's a constant theme in SIAC's judgment. They keep coming back to the idea, well, if the obligations in particular under Article 4 lead to this, that and the other species of obligation, that doesn't really help you unless you can make it sit unless you can create the nexus, I think is the idea they're using, unless you can make it sit in the context of the national security of power that is in section 40. Anyway, that's the first point, the inapptness or worse of using that as the lens. The second point is that we do, again, respectfully submit that considerable caution is needed in the light of the submissions that were made by Miss Knight. A considerable caution is needed with the repeated elision, or more accurately, the jumping between the two species of submission that she sought to make. Explain. When she wished to emphasise the modesty of the submission about the need simply to consider different legal aspects of trafficking, she emphasised the point that the threshold is crossed when there's a credible suspicion or when you simply may have been a victim of trafficking. And she also emphasised that the threshold for failure was, she put it, there was an arguable failure to protect pre-departure. All may have been possibility, arguable failure to protect by other state authorities. But when it actually came to asserting the relevance or the significance of those features, the submission morphed without acknowledgement into actual victim and actual failures. The first point perhaps to make in relation to that elision, I can use that word to summarise the point I just explained, is that SIAC only determined that there was a credible suspicion that she may have been the victim of trafficking, not that she was a victim of trafficking. And they made, and indeed could have made, no finding of breach of Article 4 by the authorities. And I emphasise that because not merely were they in no position to do so, given that the central allegations of breach rested on what the other people who weren't before the court had done, the school, the police and all of that. They didn't in fact do so, but I emphasise the point for another reason, which I will come back to, which is that her restitutionary points, you've had injustice done to you, you're obliged to do restitutio in integrum under the convention scheme, that rests and can only rest on an established breach. You don't get there just because there's an arguable breach. The restitutionary principle must be based on, if at all, on an established breach, otherwise it simply isn't in play at all. I'll come back to some of that before. But the core point for present purposes is that when assessing whether something is obviously relevant, to take that as the public law idea when you're not dictated by the statute, so as to be mandatory. And indeed it's the same point that applies under Article 4. If the case under Article 4 is now, as it appears to be, that Article 4 itself has some idea within it of mandatory relevant consideration, you need to do so not on the basis that she was a victim, but on the basis only that she may have been, and not on the basis that there was a failure to protect, but only that there may have been. And those are much, much lighter possibilities at the point of decision. At the point of decision under section 40 about whether or not in February 2019.
You mean much lighter considerations?
They're much lighter considerations, I do, that's exactly what I mean.
So
And they take one no distance, is really the point, towards the ultimate destination which she has to reach, which is obviously material. They're simply possibilities at that stage.
So there's no challenge, I don't know if there was any challenge before to the finding of credible suspicion.
No.
Live with that. And you'll deal as well, because you're talking about the allegations of breach, I think, of the protective duty, and I've got the point on board that restitution only arises if you find that breach. But there was a lot of discussion as well about the investigative duty, which
I'll come back to that
unfolds
one in the
inside
context of Article 4 specifically.
Yep.
But I'm just really on the point about repeated elision. You can see why she is eliding them, because she wants to say it's only modest, and yet when you get to it, the game she's actually got to play is this is so obviously material and so on. You can't say, and ultimately it gets you nowhere to say these are all just possibilities, that's why I suspect, that's why I suspect she ultimately below got into the logically coherent position of asserting that you needed to investigate to get to a point of certainty on those issues, as it were. That was the foundation, but she's not saying that anymore. It doesn't appear to be saying that anymore. It says, well, you don't need to investigate and get down to the point of deciding whether she's a victim. She says in broad general terms there's an investigative duty out there, but ultimately she doesn't define it, and the definition of what that involves is critical, because it's no good for her purpose. This was the point I'll come to in Article 4 and we'll see the SIAC judgment. It's no good for her to say the investigative duty has arisen because there's an arguable breach. And what that leads to is the need at some point for someone to do some prosecution or to do some investigation. It's got to tie back to Section 40. That's a significant.
Could you say a relevant consideration was the fact that no investigation had taken place?
Well, some investigation into some of the issues relating to the Section 40 power, this is going to be my third point, plainly had taken place. It's a question of what and for what purpose.
Did SIAC say anything at all about possible breaches of a protective duty by town hamlets, the police, anybody else?
Let me just double check. I'll see if I can find the paragraphs. I thought they had touched on it. I think they came to the arguable conclusion.
We talk about state failures at 224.
Yes, we did it.
Yeah,
Paragraph
92.
Thank you very much.
Thank you. Arguable, that's the one I had in mind. 92. Thank you. But you'll see why they couldn't go beyond that, because the police would have had a thing or two to say about that, and so would the school, and none of them were there, unsurprisingly, because this was an appeal in relation to Section 40. But to come back to the elision, that was no doubt why she argued the need for an investigation to get to a conclusion on those issues, at least on the issue of victim of trafficking. But the moment you start getting into that question, in other words, you need to investigate to get to a firmer place on victim of trafficking, you become mired in all sorts of procedural issues. Very often the Section 40 power needs to be exercised in a very compelling case, very urgently, and yet you run the risk, if there's a suspicion of trafficking, as there will be in very many of these cases, you run the risk of becoming mired in effect, what is a court case about trafficking. And you have to conduct an investigation, no doubt, in a case, or would have to, where the person is abroad and you can't get hold of them, and all of that in circumstances in which it is undisputed that a trafficked person, even if that be the fact, can, despite or perhaps even because of the trafficking, represent a serious risk to national security under Section 40. The third point I wanted to make by way of overarching point is that there was careful consideration of the substantive questions that bore on the national security issues. There was careful consideration of taking into account her age. There was awareness of the possibility that she may well have been manipulated, but all of that was properly done, particularly in the national security assessments, with the focus squarely on the target of Section 4. And with all of the
Section 40, yep.
Section 40, and with all of the controls that public law and the lightness of touch that public law imposes, how far to go down a particular road is a matter for rational judgment, weighting and balancing it properly for the Secretary of State and all of that. We set out the detail of that in some considerable detail in our skeleton below. I'm not going to go back to it for this purpose, but if you want it all collected in one place, skeleton below, paragraphs 64 to 87, supplemental bundle, page 225 and following. Just to pick out some of those points, the Security Service and the Secretary of State were well aware of her age when she travelled and that she married soon after arrival. See Mr. Larkin's second statement at supplemental bundle page 851 and following, making the point in effect that the age and how those who might be radicalised as minors may be considered victims, but nevertheless there was still a pressing need to consider whether they did in fact pose a serious threat. See paragraph 16 of that second statement. See for this purpose also the judgment of SIAC at paragraph 213, which is a summary of the Secretary of State's submissions on the point, with the finding by SIAC at paragraphs 290 to 292. So age and all of that carefully considered. That's A. B. Specific consideration given to whether travel and alignment was voluntary, despite the vulnerabilities of age. I think I gave you these references for, but just in case. ONS 1 at paragraph 11, supplemental bundle page 756, and the assessment made was that travel and alignment were voluntary and had been planned with some determination and with a clear intent to conceal that travel from the authorities, based in part on the acknowledgement that she knew what she was doing and went in with her eyes open as to the nature of ISIS. See ONS 1 at paragraph 36, page 760, and an assessment that she then did stay right until the end, when ISIS was finally defeated in its last stronghold in Baghdad, so that she continued to align, was the assessment. And the circumstances of her departure, according to the statement she made to the media, suggested that she only left even at the end because of the defeat of ISIS. There wasn't a rejection of or even a movement away from the ideology, as the First Times interview graphically illustrated, might be thought, supplemental bundle, page 772. That's B, travel and alignment voluntary. C is specific consideration of facilitation.
Sorry, facilitation.
Specific consideration of facilitation, and I've given you the references already, but the references are pulled together in the skeleton for the High Court further side here and below, paragraph 74.
Right, like my lady, I think you're abbreviating too much. Facilitation of what by whom?
Of her travel.
Of her travel.
Of her travel. Did someone set it all up for her and all of that?
Yeah. So, the paragraph.
That's paragraph 74 for the references into the evidence of the High Court. Skeleton. It is at least to be noted that there was, before SIAC, and they didn't, but it took a fairly forgiving view of this, but it's at least to be noted that there was no evidence from Ms. Begum to SIAC, and you'll recall that in the Supreme Court, when the first limb went up to the Supreme Court as to whether or not she had to come back for the purpose of ensuring fairness, they took a fairly austere view of the choices that were open to her, having travelled out there, which were effectively to say, well, you have a choice, effectively. You can either wait and come and give your evidence and have the position properly considered, or you don't and you carry on regardless, but with the risks that entails, and that was her decision. Again, I simply note that because, if anything, SIAC took a position which was very favourable to Ms. Begum from that perspective. We've taken rather a harder line, I have to say, on the basis that I was going to be inviting them.
Paragraph 14 of the deals with this, doesn't it?
Yeah, it does. It does, and we make no questions on that. That's a matter that we're probably open to. That's a point which is effectively SIAC operating on both taking a rather dimmer view of that position, but on the basis that the evidence was simply speculation and theorising and hypothesising from people who had not spoken to her and was not derived in any shape or form from evidence that she had given. I come back to the point finally, by reference to the open summary of the deprivation decision at paragraph 3, little e, in supplemental bundle page 742, which is that although all of these matters were carefully considered, that's what I mean by the base matters relating to trafficking, all of those points were carefully considered as going to voluntariness as one of the factors feeding into the multifaceted assessment of national security threat. Although all of that was considered, the fact of the matter remains that even if a conclusion had been reached that she had been trafficked and wasn't voluntary in any way and all of that, there would still be a very significant problem in the circumstances of her case in relation to the threat that she poses to national security. So those are the 3 points I wanted to make by way of introduction before coming specifically to the grounds. Can I then turn to ground 1, which is Article 4 of the ECHR and how all of that works? It alleges, as now presented already, a failure to consider derived from Article 4. The case appears to be, and probably has to be, in this sequence. Article 4 may have to be said, and does appear to be said, Article 4 imposes an obligation on the Secretary of State to investigate the possibility of trafficking because a credible suspicion exists that she may have been trafficked. Secondly, and critically in the logical sequence, that had to be done as a necessary part of the conducive to the public good assessment of whether she represented a danger to national security. And that had to be done under Article 4 because the state has protective obligations or obligations not to punish or obligations to make restitution as part of the operational obligations to which it is subject under Article 4. What I emphasise is now, all that is now being said is that Article 4 imposes an obligation on a Section 40 decision maker, i.e. the Home Secretary, to consider that the individual may have been a victim of trafficking or that there may have been some failure to protect before she left and had to do so as part of the deprivation decision some years later. So it appears now to be said you don't need to investigate at all on the way to that place. The overarching point, it might be thought, is that there is no case in the European Court of Human Rights or domestically that is either to that effect, mandatory relevant consideration effectively under Article 4, or remotely to that effect. In other words, that you need to consider those possibilities as mere possibilities when making a decision under Section 40 on national security grounds about whether to deprive to protect the public. So on that point, there is no support whatever in the Strasbourg case law for anything like that. So you are at the very least, we submit, in not fully confident territory, if that shorthand makes sense in the light of the Supreme Court's reasoning in AB, although it has been a little bit puzzled, but you know that it's the Ulla point revisited.
No, I know about AB. I think you're slightly parodying the Appellant argument, but anyway, don't let me derail you.
Yeah, well, there's either there's got to be some support. You've got to have some indication that Strasbourg will travel there. That's really the point about Ulla, and the reinforcement of the principle by the Supreme Court in AB, deliberately analysed the previous authorities, which they conceived no doubt was causing something of a muddle, restated the basis on which ULA existed and properly existed under our constitutional arrangements, and then deliberately, and it was obviously deliberate because they used the phrase twice in the same paragraph, deliberately cast the test as being, can the domestic court be fully confident that Strasbourg would go there? That's the nature of the test that's now put in place. So that's the overarching point in relation to Article 4. I wanted to start with jurisdiction, which to some extent bleeds into the nature of the investigative obligation and how all of that works. But at least as far as jurisdiction is concerned, can I make these points? We submit that she was not and is not within the jurisdiction. That's the phraseology in Article 1. The scope of the ECHR and its constituent rights and freedoms is bounded by that requirement in Article 1 that a person's got to be within the jurisdiction. The person that has to be within the jurisdiction of the contracting state, here the United Kingdom. The basic case law is very well known. The concept of within the jurisdiction is, as Strasbourg has very frequently put it, primarily territorial, with limited exceptions to that. In other words, extraterritoriality is in play. And there have been many attempts, notably in the context of military operations abroad, to rely on state agent authority as one of those exceptions. The European Court has rejected, and rejected early, the idea that you could bring a person within the jurisdiction on the basis of effects that were created by state decision-making or state action, effects on the person outside the jurisdiction. That isn't enough. And a paradigm example of the case law establishing that proposition is perhaps Bankovic, which was to do with the bombing of the television station in Belgrade, where the key argument being made by the applicants unsuccessfully before the Grand Chamber on jurisdiction was that it was central to the bombing, that the decision making and the planning and all the rest of it occurred on the hypothesis of the facts they were proceeding on in the United Kingdom. Nevertheless, the victims in that case of the bombing of the television station in Belgrade were held to be not within the jurisdiction, and as part of that, the court rejected any idea that within the jurisdiction created a doctrine of effects, as they put it. Two recent authorities just to note, and I don't invite you to turn them up, but at the Strasbourg level, those principles, primarily territorial with exceptions and so on, recently reaffirmed by the Grand Chamber in HF and France, with the UK government intervening. That's behind tab 70 if you want it in the raw, but the case concerned the approach of the French government to repatriation of its nationals from the camps in Syria. In other words, from the Al-Raj and Al-Hol and so on in Syria, camps run by the SDF. And at 198 to 203, the Grand Chamber rejects complaints based on Article 3, the conditions of the camp are appalling and so on the basis that persons in the Syrian camps are outside the territorial reach of the concept of within the jurisdiction, and none of the exceptions applied. As it turned out, they did find jurisdiction in relation to Article 3, sub 2 of Protocol 4, but that doesn't matter because the UK has not signed up to that protocol. It was a specific protocol that applied to France. So anyway, that reinforces the idea that the extraterritoriality remains key and important. Then second authority, this court in R3, or appeal in R3, it may be worth just taking that up briefly. Tab 71 in Authorities Bundle 3. It's one of the new ones, so you may have to search around at the back of Bundle 3. So how you put them. is a deprivation of citizenship context, as one sees. You all have 71. Paragraph. No?
It's my fault. It's not. It's 71, and I'm afraid I'm still lacking 71. I think.
You didn't tuck it in the back
I
of
did
bottle
not
three.
tuck it in the back of bottle 3. No, I'm still missing 69 through
Let me
to
give you mine.
71. Thank you very
How
much
much have a
indeed.
spare?
Is it electronically there?
See, I've got a spare.
Thank you. We'll sort it out. Thank you, Sir James.
It's been added to it.
It's a,
It may not have been added to the electronic bundle.
Right.
So
okay.
do you want
Thank
a little clip?
Thank you very
Can I have
much.
one?
Thank you. All good.
Thank you so much.
Thank you very much.
Don't need it, or you do?
I know, all good. Don't need it.
Sorry.
Thank you.
So tab 71R3, decision of Lord Justice Moylan and Stuart Smith, and again, Lady Justice Lang seems to have been very busy. And the paragraphs, so you'll see it's a deprivation. Now, it was Article 8 that was a concern, but you see the context from paragraph 1 just to note it.
Yep.
Paragraph. Paragraph 1 for the context, deprivation, and 103 to 106 was within the jurisdiction of the United Kingdom for purposes of Article 1 when the decision was made. You see the title above paragraph 103? So I just invite you to read 103 to 106. Again, that is what is, as it were, another in context reinforcement of the correct territorial approach. In fact, particularly at 103, recognising there was no decision concerning a person deprived of his British nationality outside the UK, having left voluntarily with a dual national who was living in a family unit outside the United Kingdom, and the deprivation decision was made. So that's the basic approach and the basic principle, in effect territorial, taking yourself outside the jurisdiction once you leave in that way. What Miss Knight now says on behalf of Miss Begum is, well, I'm like Rancev is really the jurisdiction case that is made now, as I understand it, based on paragraphs 288 and 289, dealing with Russia. Do you remember she took you to the bit yesterday
Yes.
dealing with Russia in Rancev?
What's wrong with that?
Marianne?
What is wrong with that analysis?
We say there's nothing wrong with the analysis of the European Court. But
The application to the facts, then.
It's the application of the facts, and it doesn't go nearly far enough for her purpose, is what in essence we say. Her complaint is now simply, that's Miss Begum's complaint, and you'll remember what they said in Rancev in that paragraph, Russia's got to investigate because there may have been crimes committed on its territory, effectively was the point. But here the complaint now being made is simply that credible suspicion and or arguable failures to protect needed to be taken into account in making the deprivation decision. And we submit, for all the reasons I've already given, that the focus is squarely and only on that decision. And it's said that Article 4 imposes consideration obligations, mandatory consideration obligations, in relation to that decision. We also note that the highest it can be put for Miss Begum is that there's a credible suspicion that Miss Begum was radicalised online by people who were overseas themselves. See the SIAC judgment at paragraph 188. And we note that in Rancev, the obligations, and this is why I say it bleeds into a which is the nature of the substantive obligation to investigate anyway. But in Rancev, the obligation in question was to investigate possible networks operating in Russia. and the possible commission of criminal offences in Russia.
But I thought the analysis, the argument here is it was an obligation to invest possible state failures here. The
Well-
police, the school, and the local authority.
My lady, well, it rather depends what the subject of the investigation which is asserted is. We're back to that point that says, is it just to look at whether the school failed or the police failed, or is it to investigate whether she was in fact a victim? Because if it's just in relation to the other lot, the police and the schools, it doesn't help them, because there is no nexus to the Section 40 decision.
Well, that's a different point, but speaking for myself, I don't think this sort of shortcut that she was abroad when the deprivation decision was made, ergo case fails, don't need to look at anything else. Why is this hearing listed for more than an hour? I don't think that works, as it seems to me, because it's part of her case that when she was a 15-year-old in Thailand, organs of the state failed in their protective duty under Article 4. I appreciate you've just made the point that there's no finding, that the finding by SIAC is only that there's an arguable case that duties were breached, not that they were in fact breached. But it doesn't seem to me, speaking for myself, that R3 gives you the knockout point
On jurisdiction.
on jurisdiction.
Oh, no, I accept that, and I hope I fairly didn't present it as being the knockout point, but it is a reinforcement of the primarily territorial thing that we're dealing with.
I did think you were using it as a knockout point. So you're saying it's a contextual point, are you?
It's a reinforcement of the basic idea of primarily territorial, and where that leads us is not to a place of saying it was Article 8 apart from anything else, so there's a different set of issues. Not necessarily to saying that that's a complete read across, but to saying you need, is the next stage of the analysis in our case, you need carefully to analyse what the nature of the decision making actually was, what is actually an issue, what is said to be the issue under Article 4, which can be brought within the jurisdiction, and it's in effect all tied back to our individual decision making on Section 40. It isn't enough for present purposes, for my learned friend to say there were arguable failures of other authorities to protect and stop her.
But then you're going back to your earlier arguments. Just on this jurisdictional point, could you just summarise for me how you put the... you say she was not and is not in the jurisdiction. The scope of the ECHR is bounded by the requirement of jurisdiction. Is it more nuanced than it's not a knockout point, you say? How do you put it in a nutshell?
That point is a knockout point when
Right.
taken to the Section 40 decision. What we say is that Rantsef is not a knockout point because that was simply dealing with a potential failure by Russian authorities to investigate potential criminal offences for the purpose of identifying and so on the perpetrators of trafficking. That is not our situation. Our situation involves an attempt to build an Article 4 mandatory consideration case into the Section 40 decision making.
But you've got to break it down, haven't you? And it may be that that's where we're all headed, but there are some stages attached to it. And what I understood the proposition based on Rantsef to be was that there was an investigative duty, and it may be with a criminal focus, it may be with a safeguarding focus, that was ongoing, and that was a sufficient reason when you came to make the Section 40 decision that you ought to at least have thought about whether you could have your investigation if you had excluded her, if you'd deprived her of her passport so she could never come back. It wasn't that the Article 4 bit in some way fed into the Section 40 assessment, it was whether you should have thought about the effect that your Section 40 assessment would have on the investigative duty under Article 4.
Yes, that's a substantive argument, and I'll come to the answers to that in due course. But just on jurisdiction, the question is how are we different from the reasoning in 289 of Rantsef? And Rantsef does acknowledge that in circumstances in which you're conducting a potential criminal investigation into trafficking that may have occurred on your territory, then that investigative obligation may need to be fulfilled come what may. because
And
it's-
why is it different here?
Well, it's different here because we submit that the focus of the whole Article 4 case now is and has to be the Section 40 decision. That's why I say, to some extent, the jurisdiction issue bleeds into the nature of the investigative obligation and what it entails. But you can't simply say, well, there's an obligation to investigate, or there may be an obligation to investigate potential state failures, where it's got excluded police, whatever it may be, to prevent her from leaving, which is the thing that creates the nexus. Ergo, that's not comparable, we submit to this.
Which paragraph is it in? Sorry, go ahead.
Should we look at Ransep? I mean, in Ransep, investigative duty was all that was left because the poor lady was dead.
Yes.
I mean, whether there was an obligation on Russia to try to get her back or to afford any other sort of protection, it was too late for that.
Yeah. And so the investigative obligation in Ransef was simply about whether or not there was an ongoing obligation on the Russian state to investigate possible trafficking rings in Russia.
And her trafficking ring, so I took that to mean that there are two ends to a trafficking, where it starts and where it ends, and that the investigative obligation points at both the beginning and the end. So why doesn't that apply when we're talking about SB, Shamima Begum? If the starting position is that she may have been trafficked, and I realise that you make some point about that. Why doesn't it?
Well, really, I'm prepared to accept, and I do accept that there may be investigative obligations, so it leads into that issue. There may be investigative obligations to try to identify perpetrators in relation to which there is a credible suspicion that they were operating in the United Kingdom, because that would fall within the remit of our criminal jurisdiction.
Not as distinct from state failures and the failure to protect,
As distinct from
which is the sort
state
of
failures.
investigation we're talking about on this case.
And short point from me: where in SIAC's judgment does it reject your jurisdiction's?
I think it's 188.
That's where it is, where he says it's far too narrow.
Yeah.
Okay, so that's
Exactly.
yeah.
Thank you for that.
Yep. And you say that's wrong,
I do, from the perspective of jurisdiction.
right?
Anyway, there plainly was jurisdiction in Ransef. There plainly was jurisdiction in Ransef in relation to Russia and in relation to an ongoing failure to investigate criminality within their jurisdiction. You can see that, as it were. But that doesn't lead to the answer, or doesn't necessarily lead to the answer here. It's still a question as to how the rationale works. Can I turn to the related issue, which is the substance of the investigative obligation? And the first submission is that the investigative obligation is a relatively high level obligation which does not touch the deprivation decision. I keep referring to Ransef, and my lord, I know wish to have it before him, so shall we go to that? It's tab 62 in bundle 3. I think the key paragraphs for present purposes are 287. That's for the well-known proposition pick it up in the final sentence before. Again, it's the references down in the footnote 105 and 106 are both to Osmond, which, as you're aware, is the Article 2/3 analogue of Article 4 at the present purposes. And so 287 for obligations to take operational measures interpreted in a way that doesn't impose possible disproportionate burdens. 288. This is the point about what does result not means mean, and I certainly don't disagree with Miss Knight's description of that. Entirely right, but it means you don't necessarily have successfully to identify and or punish.
Doesn't it start with 286?
Yes, my lord, it does. I mean, I'm not disagreeing with any of the basic analysis. Systems is dealt with in 285, operational duty in 286, including 287, not disproportionate burden, and then procedural obligations in 288. That's the way the judgment breaks down, analysing those different aspects of the implicit duties in Article 4, which my lord will be very familiar with because the same arises in relation to Articles 2 and 3. So they were hammered out in the context of 2 and 3, and they've been dragged over into 4. But so 285 is systems, 28, about which is no complaint, 286 is operational, 287 is operational, and 288 and 289 are investigative. But the focus of the investigative obligation, as described as you see, is on leading to the identification and punishment of individuals responsible. And then 289, the investigative duty then is to, which is extraterritorial, which is outward looking as it were, is to cooperate with other states who might be looking to prosecute. That's the point that's being dealt with in 289. And then if you go forward to 307, where the court comes to the facts and to the application of those to the facts in relation to the procedural obligation, you see that what Russia had to do was to investigate the possibility that individual agents or networks operating in Russia were involved in trafficking Miss Rantseva to Cyprus. But most under Rantsev, we submit, the obligation to investigate extends to trafficking offences within the jurisdiction. And of that, we have some cases in our own jurisdiction on that. MS Pakistan is a classic illustration of that, bundle 2, tab 47. And we're here not dealing with a situation where there's the prospect of immediate relief, as it were, for those suffering harm within the jurisdiction because they may have been trafficked. That's the whole NRM process. You go reasonable grounds, and all of the obligations derived from ECAT that are adopted as a matter of policy come in, and all of that. That's all within the jurisdiction. But none of that is applicable here. I actually went to Syria in 2019 and has been there ever since. Nor, I may respectfully say so, is this a JR alleging that there was a failure to investigate offences that may or may not have been committed in the jurisdiction. So even if it were theoretically possible to have that investigative obligation, even though the victim is abroad, which I would accept in general terms, it doesn't persist. Miss Begum, the flaw in the Article 4 substantive case, I submit, is that it seeks to create duties under Article 4 for the purposes of the decision to deprive. This is a very particular context. It's an appeal against deprivation, and deprivation operates on the basis of national security concerns. There's no obligation in that context to investigate to determine whether the person was a victim. There is no obligation in that sense to chase down or investigate whether or not there were state failures by the school or by police or anyone else. There may have been. That may be deeply unfortunate if there were. But but it doesn't remove or alter the focus of section 40, which is on whether or not the person is a current risk. And there is no analogy we submit with the case law on removal, MS Pakistan I've referred to already. Repatriation, we submit, is not analogous to removal. It's an entirely different state act. Indeed, repatriation isn't even being argued for anymore, although it was below, as you saw from the judgment.
What are the material differences for present purposes between removal and repatriation?
For removal, the person is within the jurisdiction, and you have certain obligations to people who are within your jurisdiction, including obligations under Article 4 and including proper reaction as per those parts of ECAT, European Convention Against Trafficking, which get dragged in to domestic law through policy. But repatriation is a fundamentally different question. And indeed, you remember from the SIAC judgment, there was an attempt to build that in through the application of whatever provision it was of ECAT that referred to that, and that is now no longer being pursued. But it's a very different thing to say we've got someone within a jurisdiction and therefore certain obligations erode in this particular way, not to remove until, as compared to taking the proactive step of trying to bring someone back or bringing someone back to the jurisdiction, if that might be or is a necessary or potentially interesting element of an investigation into trafficking offences here, for example.
MS Pakistan wasn't a national security case at all.
It wasn't. It was a criminal prosecution. The hypothesis was a criminal prosecution into those who might have trafficked in the United Kingdom. And the suggestion was, or the question was, can you remove in circumstances where it was likely that that person's involvement in the proper investigation of those offences was important?
And the proposed removal was just on the basis he had no right to be here.
Yeah.
Was it not on conducive
National security grounds at all. Distinction, I respectfully agree. And we do submit, going back to the judgment in relation to this and the nature of the obligation and what it actually entails, we do submit that the SIAC analysis at 228 of that judgment, if you could just take that up, that was correct. Perhaps pick it up. 223. Just note en passant that 222, I think my lady gave me a reference for where they dealt with Miss Begum not giving evidence. But 222, they returned to it.
Yes, thank you.
Pick up the analysis of 223. Credible suspicion is a low bar. Trafficking analysis bypasses all the more nuanced questions of that type. And that's really the 257 point that I referred to earlier, repeated or flagged. 223, but credible suspicion they accept, and then arguable of a state failures 224. I suppose they could have added at that point, and by the way, it is at least possible that some criminal offences might have been committed in this jurisdiction. Wouldn't affect the analysis that then follows. But then 227 and 228 are the core of the analysis. What she's got to show is that the exercise of the Section 40 power amounts to a breach of her rights under Article 4. Anything less will not suffice. Credible suspicion doesn't amount to that.
Is that the right question at 227?
It's 227 and 228.
Yes, can I pick back my lady's question, if I may. Is that the right question? As in light of how it's been put now, and it may be that the point was argued.
It's now whether or not.
Our question, the way it's been put for us is, or the way it's, is that there was an arguable breach of an arguable duty, such that that should have been taken into account, I suppose, as a mandatory consideration. That's the
But it
question.
goes further, doesn't it? 'Cause it goes arguable breach, triggers investigative duty. What do you then have to investigate? That's the $1 million question, on which there's lots of floating
Yes,
around.
okay, yeah.
Is it criminal offences? Is it state failures? Is it the fact that she was a victim? Is it whether or not you need to repatriate her for the purpose of the investigative obligation? But ultimately, if it's investigative, the basic idea is that she has to be here. It's the basic MS idea, but in the context of her abroad rather than someone else. It can't go on effectively, whatever investigation it may be, because she's not here. And is that something that ought to have been considered, is the way it's now put?
Yes, I mean, I think that goes a shade further than I understood the argument put, which is that, as the argument was put, it was should consideration have been given to whether she needed to be here or not in order for the investigation, the putative investigation.
Well, that's the way. That's how it's now morphed
Yeah.
into that.
But that's what we've got to deal with.
It's now morphed into that, and I've made my submissions about that, and a part of the submissions, you will recall, were the elision point.
Yeah.
I mean, you're looking at this through the lens of Section 40 is really the point.
Yeah, so it's the materiality.
And that is ultimately what SIAC is doing. It's saying you can't just establish this stuff in this way, because you could say the cops failed, or the school failed, or you should have investigated further a criminal offence that might have been committed by a nasty trafficker or manipulator in the United Kingdom. You can say all of that. It doesn't actually get you very far. It doesn't get you anywhere in the context of the Section 40 decision. The question is it material, to bring it back to her way of putting it now, is it material for the purpose of that decision to take into account these mere possibilities?
Say that a failure to consider renders a Section 40 decision unlawful.
Exactly.
That's the way.
That's the way it's now put.
And so how far do you have to get? Do you have to get yourself to a position where you can make a good argument that it would or might have made a difference, something like that? Is that how we're testing it? What's materiality? Just a rationality test?
Well, it has to be obviously material, or the Secretary of State put it technically under public law terms, because we haven't got any guidance under Article 4 at all on this issue, and it's purely a consideration thing. This is a build-out.
This is a build-out of
from
yes.
all these other strands floating around Article 4, but if it's a public law thing, the question would be, could no rational or could no Secretary of State acting rationally have concluded anything other than this was so obviously material that it needed to be taken into account? And that question, as a matter of public law, I'll come back to it when I deal with public law in ground 2, but that question, whatever number it now has, but that question is a question that must be asked in the context of, as a matter of domestic law, in the context of the nature of the actual exercise of power that is being done. In other words, in the context of Section 40.
So you say, although it's convenient to look at it as grounds 1 and grounds 2 and ECHR,
they're pretty much the same point, dressed up in different clothing.
Exactly.
That's why I started with the credible suspicion, and here are the 3 points we made. And the ultimate one of which is that they, to the extent necessary for Section 40, they considered at least all the stuff that went to the potential that she might have been involuntarily moved at the very beginning of the security risk. And it is complicated. It's complicated partly under Article 4 because there is no real attempt to grapple with any precision with what the investigation is actually doing and the extent to which that bears at all on Section 40. So although you can say, well, is that quite the right question in the light of where it's now been put in 227 and 228, ultimately that is the right focus, I submit. What needs to be shown is the nexus or the direct connection to Section 40, whether it's under Article 4 or it's under public law. Because if Article 4 is to be dragged in for this purpose, that final piece has to be put in. This is not, as I say, a JR that says you failed on Article 4 as a state because you haven't conducted a sufficient criminal investigation, or even that no criminal investigation could sensibly take place until I'm here. And if that is the allegation, which is normally the kind of MS type allegation with removal rather than repatriation, if that is the allegation, you can't properly conduct these investigations whether it be in relation to criminal offences or in relation to state failures or anything else, you can't properly conduct them without me here, or you need to consider that. Ultimately, that has to ask a question as to how is she going to get here then? And that's why SIAC were focused. That's what I meant earlier on when I spoke slightly Delphically about SIAC trying to impose the logic necessary for a coherence of the argument accurately expressed on her behalf, trying to put it as well as it could be put logically and coherently on her behalf. But if you get to that place, it does ultimately all collapse into an obligation to repatriate, or at least that is
Which
highly
you
relevant.
say, I mean, I have wondered if it actually you could just look to the end sequence of arguments and say, well, let's make
That
all
has
the
to be
assumptions
the
along the way,
punchline.
and you get to the end, and you say, query, none of this matters because you can't get her back because she's in ISIL, because she's in SDF controlled territory. First point, and second point, you'd have to demonstrate that as a matter of ECHR law, getting her back was necessary.
Yeah.
And
Well,
you
my
basically
respectful
should-
submission is that is highly relevant, and that is ultimately the analysis which, having done the logical coherence thing that I just referred to, that is ultimately where SIAC get to in 227 and 228, because they recognise that if you're going to have a shout about how inadequate the investigation is, it can only be because the person needs to be involved in it. The police are perfectly capable of doing an investigation up to a certain point that doesn't, as it were, depend upon the input of the victim. The state can perfectly coherently investigate whether the school failed or the police failed to prevent her or didn't do enough protection or precaution. Indeed, the case against Mrs. All staggeringly self-evident that they failed. They can do lots of things in relation to that without her actually being there. It might be deeply problematic ultimately that she's not there, because she might turn around and say, we don't know, as a matter of evidence. She might turn around and say, well, no, hang on a second, I know exactly what I was doing. I went off there entirely voluntarily, and or I was 15, but the fact of the matter is that I don't accept any of that. Indeed, that's quite a lot of the flavour of what comes out in the interviews, but leave that on one side. Ultimately, it's about the requisite, is her presence required? So I do respectfully agree with my lady's question. It doesn't render all the previous steps obsolete
Yeah,
necessarily.
there's quite a lot to talk about.
Yeah, but they're routes to the same end, effectively. But I do urge precision in what bit of investigation you're doing. And that's the bit that's always been opaque or oscillatory, as I described it, I hope not unfairly, because you can kind of jump from a place of denial about the idea that you have to investigate whether or not they were a victim to a place where you say, well, it's all about state failures and arguable state failures, you've got to investigate that, but then, or it's criminal offences, which is really what Ransef was interested in terms of the procedural obligation. And I don't want you to lose sight of that. I mean, the Strasbourg case law on investigation, let's make no bones about it, the Strasbourg case law on investigation is absolutely focused on identifying and bringing to accountability those who are responsible for the trafficking, particularly in a criminal sense. Obligation of means, not a result, of course. But that's what they're focused on, and that's what enabled them in Osman all those years ago to drag in these obligations as implicit, because they're not expressed in any of the articles, 2, 3 or 4. They drag them in as implicit because that procedural obligation was a necessary concomitant of ensuring that the negative prohibition, thou shalt not torture, thou shalt not traffic, thou shalt not kill, but the negative prohibition, which it is express, was given practical and effective weight. You needed the system of law to make sure that those who did breach the negative proposition unlawfully were prosecuted. All of that was a Strasbourg case law investigation is centrally focused on bringing people to account. Now, I'm not an Amin denier. Of course, there are circumstances in which there is, for example, as there was in Amin, a death in prison, and it becomes very important to investigate whether or not there was state failure. But the question that we're confronting is it unlawful under Article 4 to take a Section 40 decision without considering, as it were, do we have to bring her back because the investigations won't work otherwise? That's my lady's point about cutting to the end point, however you get but that degree of precision about what you're investigating is, I respectfully submit, important. And that's really, I think, what, if I may respectfully say so, what, and particularly one needs to be a bit cautious because of the way the arguments have morphed, but that's really what SIAC are doing in 227 and 228 and their repeated references elsewhere, including in 238, but it's that repeated returning to to the nexus, to the link to section 40. So you need to look at 227, 228 and 238 together. 238 is failed in its duties to protect. Really the whole of 238 and then that final sentence, that direct connection to section 40.
Yeah.
So we submit that there was no error in either of those paragraphs. That is indeed the correct approach, because otherwise you just, as it were, simply assert that it's mandatorily relevant under Article 4, or to take into account the fact there may have been a state failure. What Article 4 is about, if anything, substantively, forget about getting to consideration of the issue, what it's about substantively is whether or not the person's presence is necessary for the purpose of assisting those investigations. The obligations exist independently. At most, the question could be, well, you need to be here. Repatriation takes you into that turf. That's the first set of arguments, at least in relation to investigative. Bear in mind what it does and how it does, and then see whether you have to go back and can go back legitimately. And so, well, bearing in mind what the substantive obligation is investigatively, how then does that play into the Section 40 decision? Is it mandatorily relevant to consider those specific possibilities before you reach a conducive to the public good judgment? Our second submission is, I've given you the detail already, so I'll just make it, is that to the extent there was a requirement to investigate in the UK, and to the extent that that was relevant to the deprivation decision, it was fulfilled because it is to be noted the Home Office and the Secretary of State had no knowledge of her at all before she left on the 17th of February 2015, that supplemental bundle, page 46, paragraph 16. The criticisms that are made are of the police, her school, her local authority, and SIAC, we submit, couldn't possibly adjudicate on the criticisms that may or may not have been made about them, and didn't do so.
Why not?
Why couldn't they?
Yeah.
Because they were dealing with an appeal against a decision to deprive her. Those bodies were not represented before SIAC, and the function of SIAC was not to conduct some form of inquiry into or trial of those failures. That wasn't the nature of it. It was focused on the Section 40 decision.
Well, I understand that, of course. They couldn't give a judgment against the local authority, the police, and so on. Of course not. But if they had been persuaded that there were obvious failings by the state through the state in the form of town handlers, the police, and so on, could they not have said so?
Well, my lord, what they did do was to look at the arguments that were presented to them, which were very much of that ilk by Miss Begum or Miss Begum's behalf. And you've seen already the conclusions that they reached. I think it's 92 and 238, which are simply arguable.
Arguable breach by the Home Office, not. It can't be, it's not, I appreciate you say that isn't that isn't the exercise. The exercise is deciding whether the deprivation decision was lawful or not. It can't be that it's somehow unfair to the local authority or unfair to the police.
Well, there's nothing unfair to the local authority about doing what SIAC did. I certainly don't go that far. I'm sorry if I may have been misunderstood. I don't criticise SIAC for reaching the conclusion they did.
Yeah.
Au contraire, I fully accept that they acted in that way, addressing a submission made to them quite properly within the limits of what they should have been doing, which is to consider the point and to reach no greater conclusion than that they were arguable. And they weren't able to go further. I'm sorry, but I didn't mean to be to give the impression that I was being critical.
I mean, I can't see why the fact that Tower Hamlets and the police and the school were not represented before commission has got anything to do with anything with respect.
Well, it might make it intensely problematic if you went beyond a conclusion of arguable failure, if you didn't provide them with any opportunity to say why they hadn't done an arguable failure. And that would be deeply problematic in rather than anything else in natural justice terms. But that wasn't what SIAC did. So perhaps it's a debate we don't need to have. What they did was perfectly properly, simply to conclude, arguable. And I make no criticism of that at all.
Sorry, so to the extent there was a requirement to investigate in the UK, to the extent it was relevant, you say it was fulfilled, because the Secretary of State, the Home Office, had no knowledge at all of Miss Begum before she left, and then you're going on to say,
and see all the points I made earlier about
Yep.
the extent to which the voluntariness or otherwise and so on of her departure
were considered.
were considered. So to the extent that those issues, the substantive underpinnings that we made into a trafficking analysis were relevant to national
Yes.
security, they were considered. That's really the point. I've dealt with, and I don't need to repeat the point about 228 and 238. That is ultimately a focus on the correct logic of the Article 4 argument. You need to be here because otherwise the investigations can't be effective. It's that point. I've made my submissions about that too. That's the investigative duty to the extent that it adds. I should say that I hope you have the structure in your you will have the structure in your heads of the submissions. I've addressed the overarching themes, taken into account material consideration already, but I'm just picking up different aspects of Article 4 and common law. Operational or protective duty. That was that was the 286 and 287, I think, of RANSEF, dealing with that. You've seen already 238 in the SIAC judgment of making the point that Miss Begum had put herself and was well beyond the scope of the state's protection at the point of the decision in 2019. Now, there being no question now of a repatriation obligation, indeed that has now been abandoned. We also submit 238, I've made it already, but it works in relation to the operational protective duty as well, that they were correct to find that in order for the exercise of the Section 40 power to breach the Article 4 protective duty, there must be a direct connection, as they put it, between the exercise of the power and the violation of the right. So even if here one were to accept Ms. Begum's arguments that there was a past injustice that fell to be remedied, there was still no such connection. That was a conclusion in 238. And in practical terms, of course, by the February decision, everything had already occurred. She'd gone, she'd been with ISIL for 4 years. The criticisms that are made of the protective or operational duties are the criticisms of the police, our school, our local authority. The focus was properly on the national security threat in Section 40. There had been a failure to investigate those other matters properly, well, so be it. And jail if they want to, and say you haven't done enough. But ultimately, to the extent that it ties into Miss Begum at all, it could only be because they can't be done. Investigatively, they can't be done unless she's here. But that takes us straight back to repatriation. So there is a blur between investigative and operational or protective. I did want to pick up the restitution way of putting it, as she now does, and I've made the basic point already in relation to that. The idea appears to be that restitution requires restitutio in integrum, whatever that concept means in any particular context in which it's used, but it requires, on Miss Knight's conception of it here, placing her in a position she would have been in had she not been trafficked. But the difficulty with that submission is that that can only flow, that obligation is correlative to or consequential on there being an established breach. There isn't any such thing here. It might be thought not at all clear how or why, under the current Article 4 case law or at all, it could be said that a possible pass failing by another public authority could or should operate to either disable or trammel or have to be taken into account in relation to a power that is exercised to seek to protect the public. Reference was made to the recovery obligation. That's normally an obligation, as you know, from NRM as a context, the National Referral Mechanism, and people within the jurisdiction. That normally refers to assisting with all the matters that are referred to in Articles 12 and 13 of the ECAT, assisting the recovery of a person from trafficking and protecting them from future trafficking as well. But we submit that on that front, SIAC's reasoning was and conclusion was correct. Again, it ultimately may come back to a duty to repatriate as part of that, and that can't be channeled, as they put it, through the recovery obligation. That's 236 of SIAC's judgment, where you'll see the description of the argument being run in its rejection. And the ransom obligation, as they point out in those paragraphs, paragraph 236, 237, the ransom obligation is only based on the possibility of taking steps to remove the individual from the situation into which he or she had been trafficked. And that couldn't possibly apply here, we submit, not least because of the reason given by SIAC, which was that she was, at the point of the deprivation decision, already in an SDF camp. The asserted error that Ms. Knight sought to make good in this respect was based on 236 of the judgment. She says, oh, well, the fact that the person is no longer in ISIL territory does not, as she put it, extinguish the recovery duty. If you look at 236, SIAC are not saying that it did. They aren't putting it in those terms. They're responding to an argument made in the nature of the obligation evident from ransom. They're simply dealing in 236 with the duty to repatriate, or the asserted duty to repatriate, and whether it can be channeled through the recovery obligation. And in that context, and dealing specifically with the aspect dealt with in Ransom 286, in other words, removing the person from the risk of trafficking or exploitation, in that context, it was entirely right to point out, or to point to the fact that in February 2019 she was no longer in the territory. She was SDF, the SDF conditions, but she's been removed from ISIL territory, so that part of it is gone. Nothing wrong with that, we submit. Then the non-punishment principle, again inherent in Article 4. Again, our submission is that SIAC's reasoning was correct. And there is a broader concern here about dragging this principle, even if it exists and applies here, into this context, for the reason given by SIAC at 244.
Yes.
Secretary of State would never be able to exercise Section 40 power in a trafficking case unless and until determination had been made that the putative victim has not been trafficked, or possibly is no longer in a situation of trafficking. She says, oh, well, that paragraph, that's Ms. Knight says, oh, well, that paragraph misunderstands my case. I'm not saying no decision without determination, with great respect, that was what was being said before, no, not being said now, but she says misunderstands the case, simply had to take it into account.
Well, if that is her case, then this last sentence of 244 doesn't work, does it? Because if it wouldn't mean that the Secretary of State could never exercise the Section 40 power in a trafficking case without a determination on trafficking.
Well, my lord, yes, in the lighter way of putting it, I see
Yes.
the force of that.
Yes.
We respectfully submit that she does assert the need for some considerable investigation already. She has to make trafficking in effect mandatorily Article 4 relevant
Yeah, of course.
to the Section 40 decision. That's
Well,
the
you
next.
could certainly say, potentially you could say it would be a significant impediment on the ability to exercise Section 40 power.
Yes. That's really the nexus point, isn't it? That's the nexus point to Section 40. That's what led her into non-punishment. She's seeking, as a principle, she's seeking to characterise Section 40 as a punishment or penalty as a result of the fact that she was trafficked. That's the point really that's being made. She says, well, I'm in this punishment or penalty territory because I'm having my citizenship deprived because I was trafficked. But she doesn't get there unless she is trafficked. So maybe I was too quick to accept my lady's point. She doesn't get into that turf where the non-punishment principle is applicable, i.e. because she was trafficked, you can't penalise someone for trafficking or for the consequence of trafficking. But to get there, she does have to have a finding to that effect, not merely that she may have been, but that she was. But in order to escape from that, if she's right, it would have to be determined.
Yes, I remember thinking that this section, it's important to remember that 244 is in the non-punishment section.
It is in the
It's not dealing with the
yes.
Potential impediment of an obligation to consider, but that exchange does. I mean, what does the obligation to consider mean? It can't be literally just to have a thought. It has to be more than that. It has to be a sort of an assessment, a consideration.
Or to do something. But that's
you
really my
can't
point
simply say,
yes.
was she potentially a victim of? It has to be.
That's
To
really
mean anything, it has to mean more than that. So it is quite a difficult. It goes back to your
illusion.
Question of what is the duty, what is the extent of the duty to investigate?
Yeah.
Because the duty is almost what is the extent of the duty to consider.
It is almost.
If you see what I mean.
I do entirely see. And to some extent, it's an aspect of the elision point. Because if it's just possible or maybe, it doesn't take one anywhere. So you've got to chase down the facts, whatever the facts may be, failure or was she a victim or whatever. My point here in relation to non-punishment, which is why I was a bit quick to say yes to my lady.
It wasn't a fair question actually. If you take it just in the non-punishment section.
Yeah. If it's just in the non-punishment section, the non-punishment principle never arises unless she is in fact a victim. And indeed.
But unless she is in fact trafficked.
Unless she is in fact trafficked, exactly. That's what I mean. And that's particularly so, bear in mind, because, and I think I took you to a paragraph earlier, but you see it also, I think, in 223.
Are you right if you look at article, sorry to interrupt, paragraph 240 where SIAC set out article 26, are you right to say that the non-punishment principle is only engaged in the context of an outright finding? Article 26 says each party shall provide for the possibility of not, now I see possibilities in a different sense then.
Of not imposing penalties.
Right, you say there has to be an outright finding effectively.
On victims.
Yeah. Yeah.
That's I think where the word victim was chiming in my head.
All right. Yes,
yeah.
Thank you.
But you have that point. But it's not enough to say credible suspicion for this purpose. victim is a requirement on any view. And remember, as they rightly noted in 223, just to go back a bit, remember we looked at those paragraphs on credible suspicion and arguable, and it chimes with some of my points about elision earlier on. 223, the credible suspicion threshold is a low bar. Yeah, so that chimes into that. So that's the first and short answer. Nothing wrong with that reasoning. Also, and it's a separate point, but it's an important point. SIAC's conclusion was that it was not possible to be fully confident, they used the AB phraseology, that the European Court would conclude the protection under Article 4 encompasses the non-punishment principle, especially in the context of Section 40 and a public interest power of that ilk. A case has to be that the non-punishment principle, not being punished for being trafficked, as it were, or the consequence of trafficking, extends to not being deprived. Deprivation goes to risk mitigation and the protection of the public, not punishment. And the assertion in their skeleton argument for this appeal that there's no distinction between a prison sentence and deprivation, we respectfully submit, is simply wrong. It's a key distinction, the nature of the power. There's nothing in ECAT, if that's being used, as it sometimes is, as the source of discovery for new obligations in Article 4, that was the stuff that they were really considering in MS, Pakistan. But there's nothing in ECAT that precludes the deprivation where national security concerns are made out, even in a context where someone either has been or is, or may have been trafficked. There's nothing in the case law that suggests that, and indeed you can imagine there would be something of a holler from the contracting states for that to be the reason. And you can't seek to build any such obligation on however eminent the UN Special Rapporteur's reports. I'm not going to go back to the value that they had in developing ECHR obligations, again a subject the Supreme Court has gone into print on a bit. But so I respectfully agree with that 243, and we agree with that. One has, if you want the analysis of the difficulty with relying on those sorts of conclusions, you've got it in AB. Again, that's the alongside the fully confident test, the ULA test. They revisited how easy or difficult it was to drag in from that sort of material an obligation to the ECHR. And so SIAC's conclusion we submit at 246 was an entirely measured and sensible and appropriate one, certainly no error of principle. But they concluded there was more than a reasonable prospect that the European Court of Human Rights would accept the directly contrary position, namely that Article 6 of ECAT, Article 26 of ECAT, to the extent that it illuminates Article 4, a very correct addition, I may say so, it covers punishment in the form of criminal conviction, sanctions, the exercise of the Section 40 power does not entail a punishment. In that sense, VCL, on which my learned friend relied, which you went to in her opening, at 157 to 160, paras 157 to 160 of VCL, tab 64 does not assist. That case was concerned with prosecution, and therefore the non-punishment principle was clearly engaged. And so we do submit that, and this was one of our other asserted errors, as it were, that whole set of paragraphs 240 to 246 should have led, and it was an error that they didn't lead to the conclusion that the domestic court could be fully confident that Strasbourg would conclude that Section 40, in the context of someone who may have been or in fact was trafficked, amounted to a punishment. That conclusion, we respectfully submit, so it was entirely correct to reach the conclusion of principle as it did. So that's what we say about that.
But that's probably a convenient moment, isn't it?
About to go to public law.
Yes. 2 o'clock. Thank you very much indeed.